Welcome and good morning. My name is John Aguirre. I'm president of the California Association of Wine Grape Growers. Today's webinar is brought to you by Allied Grape Growers and the California Association of Wine Grape Growers. Last week, our two organizations, Allied and CAWG, released a report prepared by the law firm of Downey Brand LLP in Sacramento. The report is titled A Legal Analysis, 2020 Wine Grape Rejections. That report can be found on the respective websites for CAWG and Allied Grape Growers. This morning, we will share with you key findings and conclusions from that report. And most important, we want to provide growers with sound guidance on how they can better position themselves to ensure their grape transactions proceed as smoothly as possible when smoke events occur. At the heart of this discussion is the matter of grape contracts and how those contracts perform when there is uncertainty and stress that arise during smoke events. Before we begin, I want to make a few things clear. Today's webinar is focused on certain behaviors, actions, and decisions that occurred last year, which are described in the report and which will be discussed this morning. We did not convene this webinar to point fingers at wineries. We don't intend to sow division. Instead, we aim to provoke a discussion that needs to be had. The purpose of this webinar is to highlight those actions and decisions which proved incredibly detrimental to growers and which threaten the overall health of the wine growing community. It's imperative that we do better. And when I say we, I mean growers and wineries working together. We can't afford to repeat what happened last year. Industry sources estimate that last year, between 165,000 to 325,000 tons of California wine grapes valued at $601 million went unharvested due to actual or perceived concerns of quality loss due to wildfire smoke exposure. And the timing could not have been worse. Prior to the wildfires, 2020 was already burdened by slowing consumer demand for wine, rising wine inventories, and soft grape prices, all of which was complicated by profound pandemic-related disruptions. We now understand that wildfires will continue to occur in the American West, and we should expect that smoke-related losses will challenge growers and winemakers for the foreseeable future. But we can and should reduce or prevent the economic losses that occur when wineries refuse to accept grapes under contract that can make good quality wine. Likewise, we need to prevent the processing of smoke-damaged grapes into wine that isn't saleable and worthy of consumption. That's the challenge that confronts growers and winemakers. Today, we have three presenters who will help navigate these complicated issues and discuss the findings and conclusions of our report. They are Jeff Bitter, president of Allied Grape Growers, a marketing cooperative serving more than 400 grower members statewide. Allied markets nearly $100 million worth of grapes annually to wineries, shippers, packers, and dehydrators. In addition to managing Allied, Jeff is a fourth-generation grape grower on land he and his wife own and operate. Ashley Bolton, partner at Downey Brand LLP Sacramento. She will follow Jeff. Ashley is a graduate of the University of the Pacific McGeorge School of Law. Since working with Downey Brand, Ashley has represented clients in a wide variety of civil litigation matters with a primary focus on general business and food and agriculture litigation. Then Dale Stern, partner and co-chair of the Food and Ag Group for Downey Brand LLP. Dale is a graduate of the University of California at Davis School of Law, and he has over 30 years of experience focused on the agricultural industry. He is a trusted legal advisor to major agricultural producers, processors, and retailers throughout the states. After Dale's presentation, Jeff will return to offer additional comments and observations. When Jeff concludes his second appearance, we will entertain questions. During the presentations of our speakers, you are welcome to submit questions through the Q&A feature that appears at the bottom of your screen for this webinar presentation. It's now my pleasure to welcome Jeff Bitter.
Good morning, everybody. Thank you, John. I'm happy to be with you guys today and take this opportunity to explain and provide context for the paper that John and I commissioned from Downey Brand. In order to do that, I'm going to provide a PowerPoint presentation to kind of guide us along during the two segments that I'm going to provide. And so let me pull that up here for us. And so the first part that I'm going to talk about is really the key challenges and the grower perspective, some of the experiences we had last year and why those occurred in our opinion. And then in the second part, I'll discuss more about the observations and maybe some of the conclusions we come to. How can we react in a more appropriate way to minimize harm for growers during smoke exposure events. So we know that smoke events are no longer the exception in the California wine business. For the last 6 years running, we've had smoke events that were significant enough in magnitude to cause economic harm to the grower community. And you can see some of the main events that were highlighted over recent years here. And then of course in 2020, it was almost like pick your region. I think the entire state was impacted to some degree, one way or another, by either wildfires or some residual smoke from wildfires in other places of the state. So 2020 was certainly a much larger issue in terms of magnitude. And of course, along the way, there's been others that haven't been listed above here, but I think you get the point. We're definitely looking at a situation where it is almost to be anticipated that we're going to have to deal with some wildfire smoke in some part of the state during our growing season. The difference with 2020 was that, you know, the duration and magnitude of the event was such that it spanned the entire harvest season and affected most coastal growing regions specifically, and even the northern interior of the state. And I think I would like to caution us as an industry not to believe that 2020 was the new normal. I'm sure hopeful that it was an anomaly and that we're not going to see wildfire impact to the same duration and magnitude that we did last year in future years. But I do think we need to expect that we're going to have some regional impact from year to year based on the recurring natures of these fires. So as we look at the paper we prepared and kind of what prompted us to look at this in a more structured manner, there was real and substantial economic losses experienced by growers last year. And that really was because of the magnitude of the events, that it was statewide. It wasn't just regional. It wasn't a pocket of the industry or only certain limited growers. It was most coastal growers for sure. And again, some growers in the northern interior as well. And so the magnitude was just so much greater and the economic harm was so much greater than the past that it really prompted us to look at what can we do better. First of all, what happened? We need to evaluate what happened and how we got to where we were. And then secondly, what can we do better with that knowledge? Now for AGG in particular, we're just a fraction of the California crush, but our company experienced 80 plus contract rejections and over 12 million in unrealized sales losses last year. So it was a significant hit for us. And it really did bring to the top of our priority list the issues that we need to address in the future to avoid these same types of losses. We administer over 500 grape purchase agreements annually. So not to sound cavalier or toot our own horn about the amount of business we do, but we see a large amount of grape purchase agreements annually coming through our office from buyers of all sizes in all areas of the state. So we have a very good context on what those grape purchase agreements look like, what's in them and what isn't, and how they all compare to each other. Is there standardization? What's the relativity between the agreements? And so we have a lot of firsthand insight into the numerous variations of grape purchase agreements and subsequently the reactions to smoke exposure. So what's the issue? Well, essentially the issue is that there is no real industry standard with regard to how smoke exposure is managed contractually. And of course, the reason why I think to a large degree is that based on that first slide I showed you, we really haven't had smoke events on a regular basis except in the last few years. We didn't have to deal with that as an issue to incorporate contractually in the past. Now we've had to deal with a lot of issues contractually in the past, and that's been the basis of grape purchase agreements with regard to defining MAWG and defects and defining bricks and other viticultural targets and standards. And that's what the grape purchase agreement ultimately is. It's some guidance with regard to those issues, but smoke exposure hasn't necessarily been there. And so over the last year or two now, we've started to see many of these agreements being amended or things being added. But for the 2020 harvest, there's a lot of agreements that had no mention of smoke at all. And so as mentioned in the report, and this is a quote out of the report, many wineries interpreted their contracts to include unwritten criteria for the presence of varying amounts of guaiacol and other wildfire smoke markers that justified the rejection of the grapes. So where there was nothing in the contract, there was, there was unwritten criteria. In other words, they interpreted their contracts to determine whether or not the grapes were suitable or acceptable under perhaps other terms in the agreement. So just kind of as a visual, visual look at what are we trying to accomplish here? And so using scatter diagrams as a visual representation of the various reactions of smoke exposure, our goal as an industry should be to reduce the extremes. So currently we're kind of all over the board, right? With our reaction to how we handle exposure in a contractual context or in a relationship between a buyer and a grower. And what we would like to do aspirationally is kind of, exclude those extreme situations and bring that pattern in a little tighter to where we're operating a little bit more standardized in the industry and how we approach smoke exposure. And this doesn't mean that everybody has to have the same clause in their contract or react the same way. Obviously, in the wine business, we're doing lots of different exciting things with wine, from price points of single digit to hundreds of dollars per bottle. So clearly, this is something that we would have a varying response to, but ultimately, we have to kind of tighten this box a little bit with regard to the reactions and the relationships between growers and wineries as we move forward. So as an industry, why are we kind of all over the board in our reaction to smoke exposure? And really there's three kind of categories I would put that into. First is that we have limited conclusive data available for confident decision making. And when I say that, I'm basically pointing towards research. We need to do a lot more research in understanding smoke exposure. The second thing is there's significant differences in evaluating and understanding and interpreting smoke risk. And so each winery under each contract has different goals, different targets, different objectives in their final products. And there's also different understandings and how we approach it. So this is kind of more of a human factor with number two. And then number three, there's always external forces that influence our decisions. And many times that's out of our control. But the reality is it plays into how we react during smoke events. And so under the limited conclusive data, there's a list of predictive compounds that we're currently using. But the question is, are they comprehensive? Is this everything we should be looking at? Are we looking at the right compounds? Are we prioritizing them correctly? And then we know smoke influence varies. It depends on what's burning in terms of of the compounds that are released. The age of the smoke we know is an issue. Is it fresh smoke, or is it smoke that's been up in the upper atmosphere and settles back down into valleys? And what's the proximity to the fire and the duration of the exposure? All of these things are things that we need to understand more about as we move forward. And a lot of that is going to be done through additional research and understanding. And then there's varietal impact differences. We know that not all grapes are made the same with regard to smoke exposure. Different uptake levels, different naturally occurring concentrations of the compounds in these grapes. And so there's lots to learn there. And then tolerance thresholds are unknown. How much smoke is too much? And that could vary, of course, by variety and by type and different things. And as I mentioned a minute ago, lack of baseline data regarding the naturally occurring compound concentration. So all of these things are science. They're all things that we need to understand better by doing more research on these issues. Now, more on this human side, there's various levels of knowledge regarding smoke exposure. So some growers and some wineries are less knowledgeable about the topic and have a lesser understanding than others. Last year, when there were rejections in the Lodi area, it was interesting as I observed the reaction of growers. It was very similar to the reaction of growers in Lake County 2 years previously, when there were a lot of rejections in that region because of smoke. And Lake County in 2020, the reaction wasn't the same. They had I'll say a greater knowledge base, greater understanding of what smoke issues were and how grapes might be affected. And so there is a learning curve here. And a lot of that comes, unfortunately, from experience and what we've experienced as growers in different regions. Analysis options vary as well. We can test grapes, we can test wine, we can look for free or total measurements. There's different test methodologies. And so and those are things that are chosen by those testing the grapes. What are we looking for? Those are kind of human decisions in terms of what we're going to pursue. And then ultimately, is it the grower's responsibility to prove the suitability of the grapes, or the buyer's responsibility to prove nonconformity? And we had that issue a lot this past year, where growers would say, well, unless you can prove my grapes are unsound or unmerchantable, then I expect to be able to deliver. And the buyer would say, well, your grapes have been exposed to smoke for some time, and so you need to prove to me that they're not damaged. And so there's kind of this back and forth of whose responsibility it is. And then there's a question of reasonableness. It's technically undefined, but anytime that a party to a contract is going to act beyond the bounds of the contract, they need to justify their actions were reasonable. Was there a reasonable cause for the rejection? And so those kind of issues are gray. They're not always black and white. And then tolerance varies for many reasons, as I explained earlier, depending on the programs grapes are being used for. And again, just simple knowledge of these issues, or even a winemaker's sensitivity to smoke would cause tolerance to vary. And then you have the external forces that influence our decisions. And I would say, just as a general statement, that when a buyer is looking to buy grapes and a smoke event occurs, there is going to be the influence of the market. What's the underlying market? Is that buyer very short of grapes at the time and would be looking for opportunities to make those grapes work somehow in a program? Or are they a little long on grapes? And the reality is that they have the inventory that's sufficient to meet their demand at the current time. And so if the grapes can be proven that are not suitable for their program, then maybe it's a little bit easier under those conditions to make a decision to reject. And so the market does influence regardless of what the intent is. There is some market influences that naturally come into play in these decisions. And then we got lab capacities and turnaround time that we have no control over that would influence that. And then also, what's the timing of the smoke event versus harvest? Did the fire break out 3 days before the scheduled harvest? And how do we respond to those type of last minute disruptions in our operations? So these are the reasons why we are kind of all over the board, and we're looking to tighten these things up a little bit as we move forward. And that's really what today is about. So with that, that's kind of the introductory part of this. And I'm going to go ahead and turn it over to Ashley and Dale for them to give us a little bit more of the legal perspective.
Thank you, Jeff. Good morning. My name is Ashley Bolton, and as John mentioned, I'm a partner at Downey Brand, and my practice focuses primarily on litigation in the food and agricultural space. So, sort of jumping off of where Jeff left things, given the inevitability of future wildfires, particularly in California, and resulting smoke events, it's our perspective that the industry, from both a grower and winery perspective, would be best served to address some of these issues through more clearly defined contract language. And so that's what I'm going to focus on this morning. There's two, I'll handle two of the points, and Dale Stern will handle the other two. The first issue is about the sampling of the grapes and how that sampling will be conducted. This is an important issue to address on the front end of contracts. As we've noted from last year's experience, addressing those issues in the contract at least will provide both sides with some indication of certainty as to how this process will work. The types of questions that we think should be addressed in contracts on the issue of sampling include who will be performing the sampling. There's various options between PCAs, laboratories, whether or not those doing the sampling will be sort of jointly conducted by the winery and the grower, or if either side will be responsible for doing so. Where the samples will be taken from is another point that should be addressed in the contract. Our perspective would be that representative sampling is best achieved through samples pulled throughout the block that's at issue in the contract, as opposed to being attempting to be closest to the source of the smoke. The question of when samples will be taken is another issue that is probably one of the biggest issues that we saw in 2020 as being problematic because it wasn't addressed in the contract. The decision there obviously will depend largely on the availability of labs. In 2020, we saw issues related to labs just not being available, given the number of fires that were breaking out at the same time and the number of tests that were needing to be conducted concurrently. We would recommend that in terms of contract language, the timing of sampling be as close to harvest as possible, but soon enough to have labs available. And a lot of that will sort of be dictated by what this season brings in terms of wildfires. So the recommendation there would be to keep yourself apprised of what's happening throughout the season and sort of keep your finger on the pulse of what the availability of those third-party labs might be. The goal, of course, would be to sample and get results shortly before harvest in order to make decisions as between delivering to your contracted winery, assuming that they will accept those grapes. And if they won't, based upon the results of those tests, then finding a new home for those grapes with enough time to do so. The last issue with sampling comes down to sort of chain of custody requirements for the samples pulled, either from the vineyard or a truck. And really there's no right answer there. But we certainly recommend that those sorts of issues be addressed in the contract sort of pre-harvest so that there's no problems with decisions in that regard. The next area that I'll cover is issues relating to the testing of those samples and how those will be conducted. There's obviously choices between sort of who will be conducting the testing of the samples that are pulled. There's obviously third-party labs that are certified to do so, and assuming that those third-party labs are available, it is our recommendation that those contracts specify that third-party labs will perform the tests. But we do need to acknowledge the fact that in contracts that it's possible that those third-party labs won't be available, in which case we'd recommend that the contract actually provides for what happens in that circumstance and who will perform those tests if the third-party labs aren't available. When will the testing be conducted? Our recommendation would be as soon as possible after samples come in, or when the wine is batch fermented, depending on what type of testing is being performed. And will results be shared? Our recommendation would be absolutely any test results that are done by or obtained by either the winery or the grower should be shared in both directions. And as Jeff pointed out, given that there's no sort of uniform industry standard on issues relating to testing at this point and the need for additional research in that regard, really in sum, the point would be that testing should be conducted in a manner that is widely regarded as legitimate and valid based upon what is known currently, with the acknowledgement, of course, that there isn't a confirmed industry standard with respect to testing. But that's sort of the goal in contractual language surrounding the testing of samples. And I will let Dale jump in and discuss the other 2 points about ways in which contracts can be drafted to protect both growers and wineries moving forward.
Thank you, Ashley. Good morning, everyone. My name is Dale Stern. I'm also with the law firm of Downey Brand in Sacramento, and I've served California Association of Wine Grape Growers as their outside general counsel for going on 31 years now. So I've been around these issues, contract issues, for most of my career, and we've put on a number of contract seminars for CAWG and regional wine grape associations over the years. And it seems like every few years a new topic comes up in the world of contracts that we need to cover. And the evolution of those contract issues has been very interesting, in some cases very troubling, but also and very important to deal with as we educate both growers and wineries on ways to proactively resolve issues before the date of harvest, date of delivery, and a problem arises. And that's really the goal, in my mind, in contracts, is to plan ahead for problems that could occur, issues that might arise, differences that might be created in the field or at the grade stand in advance. And you can't account for every possible issue in a contract, otherwise you'd need a wheelbarrow to carry it around. But wildfire smoke is one of those topics, much like many years ago in the past, it became common to put into contracts material other than grapes or MAWG, mildew, and rot. And those were such important issues that over time, regulations were actually created and a wine grape inspection program was created in order to deal with those issues. And maybe smoke exposure standards is headed in that direction as well. Don't know. As Jeff pointed out, there's still a lot of research to be done. There's a lot of science aspects to this that we don't yet know. And there are a number of things that we still need to work through. And we need to do so together. By together, I mean the entire industry. Growers, wineries, scientists, universities, all of the above need to work together to try to address these issues so that we can minimize, if not completely prevent, the level of losses that both growers and wineries incurred in recent years. Jeff's list of recent fire events is troubling when you look at pretty much every year some part of the state's been impacted. And in 2020, pretty much the whole state was impacted by wildfires and smoke issues. So in our report that CAWG and Allied Grape Growers distributed last week, we identified 4 areas that contracts should really focus on in the area of smoke exposure and residues or damage to grapes. Ashley's covered the first 2 of them very well, and I intend to cover the last 2. So what smoke exposure standard or criteria should be applied? Well, again, like we've been saying all along, there's no clear-cut, one-size answer fits all. We don't know from a science standpoint, taking into consideration varieties and all of the other factors that Jeff mentioned, the age of the smoke, the source of the fuel that was burning, all those things factor into smoke exposure standards or criteria. Where I am at this point right now is we don't have clear information on what those exact standards or criteria ought to be, but it's worse to have nothing in a contract other than the usual grapes shall be suitable for the production of premium quality wine, or language to that effect, because that leaves both the grower and the winery uncertain as to whether a small or slight or a medium or a large exposure to smoke renders those grapes unsuitable for the production of premium quality wine. So something more needs to be in contracts would be our recommendation, my strong recommendation. So what thresholds for chemical compounds should be applied? We saw a number of contracts that had no thresholds, no standards at all in them last year. We saw a few, including a few proposed addendums that were developed in the heat of the fires last year that did provide some specific thresholds or criteria for chemical compounds. And the compounds that were covered by those criteria varied. Many of them covered the 2 that we've all heard most about, guaiacol and 4-methylguaiacol. But there's a number of other chemicals that have been determined to have potential effect on the quality of grapes and wine. Cresol, syringol, and a number of others. So what chemical compounds exactly will be considered as part of the testing and sampling and testing that Ashley talked about? I recommend that those chemicals be identified in the contract, that they will be expressed as one of the standards or one of the criteria that will go into a decision as to whether or not grapes should be accepted. Once you identify which chemicals, then what thresholds apply? A lot of contracts that do mention smoke or taints refer to words like shall be free from. Well, free from in the literal sense means 0 tolerance. Absolutely no testable or no determinable criteria or presence of smoke will be permitted. Now, with laboratories able to test down to fractions of parts per billion these days, I'm not sure that a free from criteria is necessarily appropriate from both the winery or the grower standpoint. And it's, as was mentioned earlier, some grapes have a baseline level of some of these chemicals in them right from the beginning. So I'm not sure that free from is the correct term. I'm also concerned with language like shall have no detectable guaiacol or 4-methylguaiacol or other chemical in it. What's detectable? Well, last year, most of the labs that were involved in this were able to test to 0.05 parts per billion. But next year, maybe the labs get a little better and it's 0.04, 0.03. So if we say no detectable, as soon as it registers on anybody's lab equipment, now it's detectable. Does that create the basis for a rejection of the grapes? From the grower standpoint, I'd want to pick a number, the number that both the grower and the winery agree will have an impact on the wine that's made from the grapes. And as was mentioned earlier, it may depend to some extent on what program the grapes are destined for, whether it's a everyday table wine or a high-end restaurant wine might play a role in determining what those thresholds or criteria for each chemical will be. The point is that these issues should be covered in a contract and should be agreed upon between the grower and the winery up front, so that we don't end up in a situation like we've been in recent years where there's nothing determinative in the contract and it's left to just one party to the contract to make the call. They're not going to be certain what criteria to apply, and the grower is not going to be certain what's going to be applied to their grapes. It leaves everybody in the dark. Having clear thresholds or criterias alongside each listed chemical in a contract or in an addendum or in a policy from the winery, something that makes it clear what's expected of the grower and what the winery is going to be testing too. Some contracts in many wineries include a sensory analysis as part of their decision whether to accept or reject grapes. Sensory analysis is very important in wine. Obviously, wine is sold to the consuming public based in large part on sensory standards and criteria. The concern we had last year was with contracts that simply said that a sensory analysis will be performed to determine whether the grapes were affected by smoke exposure. And in our experience in talking to many growers, not only this last year, but in previous years, that's too vague. It's unclear as to what is expected of the grower when they deliver the grapes and what the winery's standards or criteria are going to be. If it's left entirely to the subjective analysis of any one person or group of people, there should be some criteria attached to it. For example, how will the sensory panel be performed? Is it one person? Is it multiple people? All of the factors that go into a judging of wine, a tasting of wine, drinking water in between each taste, a period of time that passes between each taste of the wine, clear and concise notes on a grading scale, and the results are available to both parties to a contract. All of those issues should be considered for inclusion if sensory analysis is part of the criteria for acceptance or rejection of grapes. I also believe that if sensory analysis is going to be used, it should be coupled with lab results and not stand alone. In other words, the criteria for acceptance or rejection shouldn't simply be a sensory analysis. It should be a lab result coupled together with a sensory analysis. So for example, if grapes test and there is detectable presence of guaiacol, for example, then the sensory analysis should be coupled with that, could be coupled with that, and made a part of the ultimate decision whether or not to accept or reject the grapes. As we saw last year, there were some grapes that tested well above the detectable levels of guaiacol, but when the wine was made, several sensory panels were run and there was no detectable damage to the wine at all. And I'm sure the reverse is true as well. So I would recommend that any sensory analysis be coupled along with lab results that have clear criteria as well. Then test results. As Ashley mentioned earlier, we think test results should be shared between the grower and the winery. And many growers had their own tests performed, ran their own samples to the labs. And they should share those results with the winery as well. So the results sharing should go both ways so that everybody is fully informed. And if there's a difference between the two results, that can be analyzed and determine whether it's a difference in lab methodology or a difference in location in the vineyard where the samples were pulled, or time of sampling, and so on. But the question of how the test results will affect the winery's decision to reject grapes or impose a price adjustment, that's an issue that we believe should be covered in the contract. So for example, if it's detectable but below X parts per billion, pick your number that you like best, the winery, will the winery be entitled to reject the grapes, or will they impose a price adjustment to those grapes? If it tests above Y parts per billion, a higher number, then the winery can reject the grapes. Those kinds of things, if that's what you, the grower, and the winery agree upon, those are the kinds of things that should be covered in the contract or in an attachment to the contract, some way to where it's part of the agreement between you, the parties, so that you're not left wondering what's being done and why the decision was made to reject the grapes at the time of harvest. So those are those four components, the two that Ashley covered and these two that I've just now finished going through, we believe should be critical components to contracts, particularly with the increasing prevalence of wildfires and the increasing concerns about smoke exposure in the industry. And at this point, I'm going to turn it back over to Jeff and let him cover some additional points that are on his PowerPoint slides.
Great, thank you, Dale. And bring mine back up. And so now we'll move into part two of my discussion. And some of what I'm going to say here will echo Dale a little bit. But I want to bring some of this to the next level in terms of how do we incorporate these ideas into Grape purchase agreements so that we can do a better job of working through smoke events. And this is based a lot on our observations and insights. Like I said earlier, we administer 500 grape contracts per year. And so we have a lot of experience with what happens when there's trouble and how do we work through that. We have a lot of great relationships with buyers that we mutually want to see ourselves through these situations. And so we have some experience with what works and what doesn't. And so I'd like to share that a little bit. So first of all, one of the problems we've seen is what is the definition of smoke taint exactly? You hear a lot of people say that it's a buzzword, but is it really defined? Is it the mere detectable presence of smoke compounds? Or is it, actually describing the commercial viability of grapes and wine? And in other words, is there a graduation from smoke exposure to smoke impact to actual smoke taint? And that's something that needs to probably be defined or understood, at least between the parties of the contract. The word taint is often used very loosely in contracts. And since there's no standard industry definition for smoke taint, it quickly becomes a matter of interpretation between the parties. So here's an example of some problematic language in a agreement I signed recently, or that we were party to. And it basically said, and we were selling bulk wine under this particular agreement. It said this: to the seller's knowledge, the wine is not damaged, defective, or spoiled in any respect, and the wine is free of any wine faults, smoke taint, or other contaminants. Now, the interesting part about this wine and this clause in the contract, in the purchase contract for the wine, was that the wine tested at 8 parts per billion of guaiacol. This is a 2020 Zinfandel that was from Dry Creek Valley, very clearly affected by smoke, and tested so. And we were basically making the representation that under this agreement, it said the wine was free from smoke taint. And I called the buyer and I said, I can't do that. It's not free from the impact of smoke. And his response was, well, no, it's not smoke tainted. The wine is fine. I tasted it. It's beautiful. It works perfectly in my program. And so his definition of smoke taint was that it actually impacted the merchantability of the wine. And he did not view smoke taint as something that was just merely detectable, that it was the presence of smoke compounds. So it's important to differentiate between those two things with the buyer of your grapes, or as a buyer with the person you're buying your grapes from. So the solution direction here is to clearly define what taint is and how measured, or simply refrain from using the word taint in your contract and utilize and incorporate written objective parameters for quality evaluation. And I think Dale did a good job of kind of walking us through what that would look like. Many active grape purchase agreements are devoid of a clause that provides remedy in the event of smoke exposure. And we've already talked about this quite extensively during this seminar. But when there's no clause, it leaves the determination of suitability much more open for interpretation. And you end up often relying on other quality statements in the contract that imperfectly address smoke exposure. So I think that we've come to a point now where the evaluation of smoke impact is important enough with regard to quality standards that there ought to be specific verbiage addressing it. Like we said before, 10 years ago, maybe it wasn't an issue, but today it is. So as Dale made the clear point as well, we really need to make sure that we have an agreeable smoke exposure clause in the contract that you're offering or signing, or discuss placing a mutually agreed amendment in place. If you have a contract that's devoid of and it's currently active and devoid of any type of language or verbiage on smoke, probably ought to talk to your buyer or talk to your seller, whoever you're buying the grapes from, to place an existing or to place an amendment in an existing contract prior to the next smoke event. Now, it is possible to go too far, and I don't intend for you to read this. That's not why I'm putting it on the screen. But what I've done here is I've highlighted the smoke exposure clause in a recent contract that we were offered. And the contract prior to the smoke exposure clause was a one-page contract. Now, that can be argued that that's too simple, and contracts ought to be more than one page. But the point is that now it's a 2.5-page contract, and 1.5 of the pages are smoke language. And so I think it is possible to go too far with the language, and it should be in line with and balanced with the rest of your contract in terms of what you're trying to accomplish. If you have a 20-page contract, then maybe 1.5 pages on smoke is appropriate. But if you have a 1-page contract, 1.5 pages is probably a little bit aggressive. And as Dale said, in contracts, we can't accommodate for everything, or like he said, we'd be using a wheelbarrow to cart around the contract because it would be so big. So we need to just move more toward a middle ground here, and putting appropriate language in contracts and not trying to solve every potential problem that may come up in the event of smoke. Another problem we see is one-size-fits-all smoke exposure clauses. And we're seeing that a lot now because wineries are engaging legal counsel to write smoke exposure clauses for them. And legal counsel isn't so interested in maybe knowing all the nuances of smoke and writing that into the agreement, or even talking with the wineries about, do you have different criteria based on the grapes you're buying or the programs that you're going into. Their interest would be in what clause do I write to protect my client? That's what they're in. That's where they're coming from. So when they write a clause for smoke exposure, it's often we're seeing they're very aggressive, and they're very protective of the winery, and do not lead to much leeway with regard to dealing with smoke exposure events. It shifts all the power and control and decision making into the winery's hands. And what's more is that we're seeing the same contract clauses popping up in various contracts across the industry. So it seems clear that maybe there are a handful of lawyers out there writing smoke exposure clauses that they're just distributing to all of their winery clients, but there's no differentiation based on what's happening in each situation. So the issue there too is that we're seeing these clauses become part of the template rather than the vineyard specific quality parameters. So when you negotiate a contract with a winery, there's often the boilerplate contract verbiage, but then there's often, and there always will be, the verbiage specific to what they're buying, how much they're paying, what the quality parameters are, what the bricks targets are. This is where smoke really should fit in. It should be a negotiation. It shouldn't necessarily be just a boilerplate paragraph in all contracts. Now, we know from work done in California and Australia that different varieties have different baseline concentrations. And obviously we've talked about this, but much more work needs to be done in this area so that we can accommodate for these things when we're writing contracts. And so we anticipate a greater ability to do this as we go forward. And then of course you have standard processing procedures like removing the skins before fermenting whites, as well as various elective processing options that may adequately mitigate smoke impact in certain wines. So a one-size-fits-all smoke exposure clause doesn't necessarily work, considering that not all grapes react the same to smoke during fermentation. So the solution direction here is to discuss and negotiate the specific tolerance for smoke impact based on one of three things, or all of these things: type, variety, and price point. So in order to make the example, I'm going to exaggerate the example here. If you have a contract issued by a winery to a grower that's growing a $10 bottle of Sauvignon Blanc versus a grower delivering or producing a $100 bottle of Cabernet Sauvignon, and that winery is using their template contract, it's probably inappropriate to expect those same standards for these two very different situations. You've got different type, white versus red. You've got different varieties, obviously, and clearly different price points. And so maybe that smoke clause ought to be tailored to accommodate that. Now, Dell covered this very well, so I'm not going to go into too much more detail on our concerns about sensory evaluation. But to Dell's point, it should not be that that evaluation alone is what determines suitability under the contract. Research shows that exists varying sensitivity to the impacts of smoke in wine. So in other words, not everybody exhibits the same levels of sensitivity or perceptibility when it comes to smoke. So if you have a contract that says the winery will accept it as long as it passes the sensory evaluation of our winemaking team, but the winemaking team is all very sensitive to smoke, then you're not in a very good position versus dealing with a winery where the winemaking team may not have that same level of sensitivity to smoke. And so these, as Dale said, this should always be coupled with objective measures. And so where we did see this work last year and in the past, and where I do encourage sensory evaluation, is when you're trying to classify wine for payment purposes and otherwise. So let's say a wine or a grape subject to rejection or subject to price discount based on the objective measures. Let's say it has 2 or 3 parts per billion of some smoke markers. The winery goes ahead and brings that in on condition that they're going to now do a sensory evaluation on it. And we already know the wine is smoke impacted. We have the numbers that show that it is. And maybe based on the sensory evaluation of the winery, then we classify it into different uses internally for them. They may say, no, I can use it for a certain program. And so I'm willing to still buy it, but it's not of the quality I need for the program it was intended. So there's a discount. And so that's where sensory evaluation is very important. It really is in terms of slotting wines where they might fit in wineries that are able to move those around, or otherwise move wine into the bulk market for liquidation if that's the option. What we had last year as well was we had situations where there was no objective measures. There were wineries coming out to vineyards with smoke in the air and then tasting the grapes and saying the grapes tasted like smoke, which I think some of the researchers have very clearly stated that's not a viable evaluation method to chomp on a few grapes in the field and say they're drying or parching and so they're smoke tainted. So we've seen that as well as kind of our concern with sensory evaluation, that extends backwards into the field and there's never even a chance from the standpoint of measuring or delivering to a certain quality of those grapes or wine. And then next is the testing methodology. Targets and results for grape and wine analysis can vary in nature. So are we measuring the right compounds? There's considerable speculation regarding the predictive qualities of various compounds. For example, it's been shown that syringal may not correlate with other measured compounds in the same manner that those compounds correlate with each other. There's also some speculation we may not be fully recognizing all or even the best compounds associated with smoke impact. So again, this is an area we need to do more research. This is nobody's fault. This isn't a finger pointing exercise here. This is just stating the reality and the obvious that there's more work we need to do as an industry to make sure we understand what we're testing for and whether or not those are truly good precursors. Are we utilizing the right methods to test grapes and wine? When fermentation is emulated in a laboratory setting, is it a reliable method to evaluate those grapes? Because what we see oftentimes is that the finished wine results may not match those pre-harvest analysis. And so there is a question about whether or not the procedures being performed are actually a true evaluation and a true representation of what that finished wine will look like. And of course, some of the questions here are, well, yeah, we can see what that finished wine looks like in 6 weeks, but do we know what it looks like in 6 months or 6 years? And again, those are questions that we can't answer at this point, and it's going to take a lot more experience and also research to understand those things. And different buyers rely on different measurements. Some buyers are fine with looking at free measurements of guaiacol and 4-methyl guaiacol, where others want total measurements of all compounds. And so you have a different approach that we need to understand that exists as we're negotiating grape contracts. So the solution direction here is to be aware of and agree upon the methodology and protocol used in evaluating grapes or wine for smoke impact. Currently, the most widely adopted method involves the measurement of guaiacol and 4-methyl guaiacol by certified commercial laboratories. That's what we see the most in terms of our grape contracts and in terms of what governs the decision-making process under smoke exposure event is a commercial lab doing these tests. That doesn't mean that there's not other options out there. There clearly are. It doesn't even mean that that's the best option, but certainly that's the most widely adopted method today in the industry. Okay, so kind of getting towards the end here and talking about what's worked for us and what doesn't work. What's worked is post-harvest evaluations when necessary. And that would entail, of course, bringing the grapes in on condition. And this isn't always possible. We fully understand that not all wineries are equipped to bring in everybody's grapes and keep their lots separate, do separate evaluations. That's very clear that could cause a hardship on a winery. But when possible, and when the relationship is strong enough to move in that manner, those have worked very well for us. We can truly evaluate when a wine has been impacted by smoke and whether or not it's merchantable. Scaled pricing based on objective measures has worked for us, where we say, okay, there is a tolerance for smoke, but as there's more presence of the smoke compounds, then our price is going to be adjusted. That inherently is fair and equitable in evaluating a wine or grapes for suitability. And that has worked for us. And that has worked in the contract sense in terms of actually being written in the contract and having the grapes tested. And it's also worked and in post-harvest evaluations when we've said, okay, if it scores between these numbers, X amount will be paid for the grapes. And if it's higher, then it's going to be less and whatnot. And so that has worked. The other thing that has worked is mitigating the risk with crop insurance. Crop insurance is a very important tool in mitigating the risk surrounding smoke exposure. I would encourage all growers that are particularly those growing in coastal areas to be engaging with crop insurance agents. What doesn't work? Quite simply, rejection with detection does not work. That's a one-size-fits-all application. It's basically a simpleton way to write and put in a contract that there's smoke damage to the degree that it's going to make grapes unmerchantable or unsound. And that is a problem that we see developing today, is that the reaction to the smoke exposure events we've had is that there's just, well, we're going to reject the grapes if we detect anything. And in my little scatter diagram earlier, that's part of the dots that are way outside of the realm of where we should be operating as an industry. Just because we can measure something down to a half a part per billion does not mean that that should be the defining factor on suitability under a GRAPE agreement. Subjective evaluation and decisions unsupported by objective measures do not work. That we've talked about that in detail today. And treating smoke exposure as a black and white issue really doesn't work. Grapes don't go from perfectly suitable to completely unsound and unmerchantable. There's a big gray area in between. And so the more that we can have conversations about where do these grapes fit and what is the value of these grapes based on their condition, the better off we're going to be, as opposed to treating it as a black and white issue. And then, of course, what doesn't work, is Dale very clearly stated, as well as I have, contracts without smoke clauses do not work. So there needs to be some written criteria in these contracts to help guide us in the future. So in summary, the risk-reward trade-off becomes the determining factor with regard to negotiating an agreeable agreement. There's a lot of risk involved with dealing with smoke exposure issues. And it's that trade-off, it's that dance, if you will, during the contract negotiations where some of this needs to be surfaced. If a winery has a no tolerance policy, let's say that the winery is producing, $100 bottle of Napa Cabernet, and their contract says we have no tolerance for any detectable amount of smoke. Okay, that's fine. I'm not saying that the winery should not take that position, but the reality is that shifts an incredible amount of risk onto the grower. He's got to produce a perfectly clean product. And so what is that risk worth? What does that risk cost? He's certainly going to go out and try and ensure to the maximum he's able to hedge or mitigate against that. But the reality is there is a risk-reward trade-off when those types of positions are taken. There are open lines of communication regarding smoke. It doesn't have to originate from the buyer. Growers, as a grower community, we can initiate those conversations and say, how are we going to handle this if this event occurs? So I encourage growers to engage their wineries if their winery does not have a smoke clause and if it's not being talked about. And then consider the cost of crop insurance during the contract negotiations. Crop insurance is an effective way for growers and wineries to work together to address smoke concerns, but it does come with a cost. So ultimately, as the cost of producing those grapes increases over time, the market responds and grape prices should increase. But when you're going from no crop insurance to crop insurance because of a clause in the contract, then that should probably be addressed at the time of that negotiation. And then ultimately, as an industry, we need to move toward that more of a uniform reaction to smoke exposure and reduce or eliminate the outlying behaviors that damage either party unnecessarily. And again, this kind of goes back to my scatter diagrams, where we want to tighten that box a little bit of the realm of where people are working within. And try to standardize some of this. A lot of this is going to come with increased knowledge, increased experience, and certainly increased research. So here's to the 2021 harvest being smoke-free. Maybe none of these things will matter this year, but they certainly will matter for the future, because I think we can all agree that we probably haven't seen the last of smoke events in California. So with that, let's go ahead and turn this back over to John, who's going to moderate some of our question and answer time for our viewers.
Thank you very much for that, Jeff. Let me just post here a disclaimer. And the disclaimer is that we're going to have a discussion about some of these issues and respond to some of the questions that have been posted. But what we say in this webinar does not constitute legal advice applicable to any specific set of facts and circumstances. So thank you very much, Jeff, Dale, and Ashley. We've got some great questions here. So one question I have, just going back, Jeff, to touch on the crop insurance issues, we've seen some growers have indicated to me they're being required by their buyers to purchase crop insurance. And in some instances, as a condition of the contract, in some instances, buyers are sharing in that cost, and in other instances, not. And in the instance where they share in the cost, that feels like a partnership to me. But can you elaborate more? What can a grower do about that, or should they do about that? And what are the contractual implications? Dale and Ashley may want to weigh in on that.
Well, I'll say from the standpoint of why those would be introduced into contracts, it's clearly with the intent to mitigate damages if there is a dispute over the suitability of grapes under the contract, and the dispute advances into a setting where there's legal issues, then the wineries are, how should I say this? The growers need to mitigate their loss, but the wineries are essentially only on the hook for what portion of that loss wasn't mitigated. So if they're able to mitigate the loss through crop insurance, then they're not able to collect a crop insurance indemnity and then also sue the winery for the full value of the grapes. And so that's why we're seeing these in contracts. It's in an effort to reduce the liability for the buyer in the event that there is a rejection and there's a subsequent dispute.
Yeah, let me add to that. That's exactly the way I would have said it as well, Jeff. And John, because of what Jeff just said, I would add that the beneficiary of the crop insurance, of course, the grower is going to benefit by having insurance, but the winery is also benefiting. And by requiring that insurance premium to be purchased as part of a contract provision, it seems to me as though it's far more reasonable for the winery to also agree to offset some of that premium cost, since the winery is requiring that for their benefit. And for the partnership reason you mentioned earlier, to further enhance the relationship between the grower and the winery, I would come back and say the winery needs to share in some of that premium cost in order for the partnership to be real.
And I'll add to that sharing doesn't necessarily mean that the winery gets half the bill for the premium, but that the price that's offered to the grower is reflective of the fact that there's this additional cost. And we have wineries that have incorporated those clauses into contracts. Some of the ones we've dealt with that have that clause are paying premiums in the marketplace, and we're happy to accommodate in that case.
Thank you. Now, I see a question posted about timing of testing. And so if you address this already, my apologies. I'm trying to manage the questions and also listen to the presentations. But the question is about the timing of testing and the reality that you've got free forms of these smoke compounds when the grapes are processed. And then you have these smoke compounds in bound form. And over time, the bound forms of those compounds can release. So clearly that's a risk on the winery side. So what is the appropriate time to test is the question, but maybe it's more appropriate to ask, how does the grower relate to the winery in terms of that particular risk of damage appearing later in the process?
Well, I think I'll take a quick stab at that. The appropriate time to test, of course, would be as close as possible to the harvest time, because you want to get as much of a reflection of what that wine will turn out like as possible. But I see this, along with many of these issues we've talked about today, as being negotiation points, because there are options. There are different ways we can approach this, and there's different preferences depending on who your buyers and sellers are. So I don't know that there's a right answer. What's important is that the two parties agree to what they're doing and when they're going to do it.
Yeah, I agree with that. If the wildfire occurs 2 months prior to harvest, then we have a lot more flexibility in scheduling that testing. If the wildfire is occurring at the same time or within days of harvest, then it's a lot tougher to have a predetermined schedule for testing. But clearly, you need to back into it. So, for example, if the testing is going to be of chemicals in the free state on the grapes, then you could do testing as close as 3 or 4 days prior to harvest, assuming you can get the lab results back in 2 or 3 days. Then that way you'll know the results prior to harvest. But if you're going to be batch fermenting the grapes into wine and then sending samples off to the lab for testing, you're going to need to build more days into that time frame so that you can get the results back prior to harvest. The worst case scenario is for the grower to go through the cost of harvest, show up at the winery with the grapes, and then learn that those grapes are being rejected based on a test that was just performed. If the grower knows as many days as possible prior to harvest that there's a problem with the grapes, then they can explore other opportunities, other options, and get their crop insurance claim in as quickly as possible if necessary.
Well, makes good sense. And it's been said before, uncertainty is going to continue, and we need to return to good communication and transparency. So thank you very much for that. Another question I have is, some growers have asked about the issue of harvest scheduling. And I've heard from growers last year who were frustrated that they were staring down an imminent smoke event, and the winery had pushed back their scheduled harvest date for reasons that weren't entirely clear. And then, of course, the situation became complicated when the smoke event descended on that winery. So I guess looking forward in the future, what can growers do in those circumstances? They've got a scheduled harvest event, if you will, and they're looking at a smoke event as well in proximity to that date. They want to get the grapes harvested. You have any suggestions or how to respond to that situation?
Well, sure. My suggestion would be that in many contracts, we see language to the effect that the harvest schedule, the harvest decision is either entirely the winery's call to make, or it'll be made jointly, which means that either party can say no or yes to the harvest decision. And so having a little more clarity, a little more detail in the contract as to how that decision is going to be made, particularly in the event of a smoke event approaching or ongoing, would be helpful to the parties. Last year, several growers that contacted us were being told by the wineries to delay harvest, and they approached the winery and proposed, let me go ahead and get the grapes out of the vineyard, and I'll take them to a different custom crush facility or a different location and have them crushed and put into a tank, and then you can pick them up later down the road when you want to. And there were some wineries that were willing to do that, which benefited everybody. Obviously, a lot of the custom crush facilities were inundated with grapes last year, so there may not have been a lot of room in the 2020 example, but that's one option that should be considered. I know some winemakers are very sensitive about not being involved directly in the crush and trusting some other facility to do so. But those are all things that a grower and a winery could talk about in advance as they're preparing their contract. What custom crush facilities do you respect, Ms. Winemaker, so that if there is a smoke event, I can take my grapes there rather than wait for you to allow me to harvest while smoke is getting closer and closer. Those are things that could be done to help alleviate some of the problems.
Great, thank you very much, Dale. So as we develop the research and we can answer some of these questions that help reduce the uncertainty, that is background level of smoke compounds, thresholds where smoke compound levels affect sensory perceptions of wine quality, obviously the situation is going to be improved. Now, give me your opinion on the value at a future date of a third-party inspection program. We have the wine inspection program, the wine inspection committee. Do you think these issues can be addressed and dealt with effectively in the future through a third-party inspection program?
Well, I think from the standpoint that we can quantify smoke impact under different situations with regard to varieties and types and maybe even price points, all those types of things, all the considerations that come into whether or not grapes would be suitable, then yes, that's probably something that would work down the road. We need to be able to measure it and have it done by a third party ideally. But the reality is that, today we can't do that quick enough, like we can quickly measure the other quality standards in the contract. So we have that against us. And unless we develop the procedures to be able to quickly ascertain whether or not grapes are, impacted by smoke and to what degree, I don't see that being something that immediately falls into a third-party realm, at least not in the immediate future. I think that's a lot of work needs to be done potentially to get to that point. But for the same reasons that third-party inspection exists for the other things that we currently measure by third-party, smoke certainly fits into that, right? Because there is lack of conformity or uniformity in the industry. Again, back to my scatter diagram, people are kind of all over the board on how we're handling it. And so to the extent that can be tightened up by a more regulated evaluation process, then yes, I think that's appropriate to say that could be an answer at some point in time.
Thank you, Jeff. And then we have a question which really goes to the heart in many respects of the challenges that we saw last year. But one of our attendees asked, they provided samples to UC Davis, and the sample results came back negligible presence of smoke-based compounds in their grapes, but the contracted buyer still refused to purchase those grapes. So, that speaks to if a grower has different sample results and different interpretation than what the buyer has, all right, what recommendations do you have for that particular grower?
Ashley, do you want to take that one?
My answer is not going to be very comforting, but it would largely depend on obviously the terms of the contract. It's something that we did see in our analysis in putting together that report, circumstances in which results from the grower differed from the results from the winery. And it would largely just depend on what the terms of that contract are in terms of whether or not there would be a basis for rejection in light of those conflicting test results.
I would add to that if the grower's grapes are being rejected, the grower needs to remember that if they do have any thought or possibility of pursuing a claim that the winery unreasonably rejected their grapes, the first thing the grower needs to do is be aware of their duty to mitigate. In other words, they can't just sit back and cut the grapes on the ground and take a full loss. They have an obligation to attempt to find another home for those grapes, consider custom crushing as an option, as a way of trying to recoup as much of those losses as they can, so that in the event that they do ultimately decide to present a claim to the winery, they have reduced the claim as much as they reasonably can to a smaller number. So I'm not advocating that growers should go out and file claims against wineries, but if you find yourself in that situation as a grower, remember that you have that duty to mitigate your losses by trying to recoup as much as you can from any of the available options out there.
Thank you for that, Dale. I appreciate that. So we're coming to the closure of this webinar, and we may not have answered everyone's questions. I would like, before we conclude, just to have those of you who are willing to make yourself available to questions from attendees by email. But I'd also like to ask our presenters any final comments that you would like to make before I wrap this up.
Well, I did see a question that had to do with is there model language for contract clauses that exists that can serve as a as something that parties could talk about, and I don't know that there's model language out there per se, but certainly some could be developed. But again, because of the nature of the differences that are these our grapes are used for in different programs, different price points, all of that, there's going to be differences potentially in how those smoke clauses should be incorporated and what they should say. But going back to the question, is there a model? The model is kind of following what's been given during this webinar today. Considering the things that we've said that are pitfalls and the things that we said have worked. And so you'd look to that as an outline to craft that model paragraph.
John, as to the first part of your question, I would encourage folks to send emails through CAWG or Allied, and then those that are appropriate for Ashley or I to look at and respond to. I'm not going to volunteer Ashley's time, but I'll volunteer mine. I'll attempt to respond to questions that you or Jeff think should be directed on to us.
Yeah, I was just going to say that, Dale, and that's what I'll do. I'll offer to all of our attendees, if you have questions, then send me an email at John, John, at CAWG.org. That's John at CAWG.org. And I would be pleased to connect you to Jeff Bitter or Dale Stern, and we can return a response to you. Also, we will make today's presentation in recorded form available on the CAWG website. I can't promise that we'll get it up today, but I will work with my staff to make sure that we get it up by Monday. So a recording of this webinar will be available on the CAWG website, and we'll make it so that it's available to any industry member and easy to get to. And with that, I want to thank our presenters for their presentations today. I want to thank them for their work and leadership on behalf of the wine growing community. What we heard some of the challenges and the difficulties that we experienced last year. We had a good discussion around the contractual aspects of those issues and what growers should think about, and wineries, when we're dealing with these issues in the context of contracts. And then Jeff Bitter reviewed for us what works well in terms of grower-winery cooperation and what doesn't work well. So all very good messages. And with that, I want to say thank you, and we'll sign off.